All right, gentlemen and ladies, or as we call it, gentlemen and gentlemen on skirt. This is Prof TV. I have been taking us on a ride under law of contract. Sorry for my voice. I've not been really, feeling so good, but the work must be done. So we've been doing a lot of law of contract. We've been doing elements of contract. We've been on element of contract for a long time. We've done offer. We've done acceptance, and now we are going into consideration. So we've done offer, we've done acceptance. We've seen that when a contract is supposed to come into place, or when a contract is said to have come into place, there are elements that must be there. There are elements that must be present. And we talked about the elements. We say offer acceptance, we said consideration, we said intention to create legal relations, and capacity. Of course, we also talked about some arguments surrounding capacity. So we've done offer, we've done acceptance. And you've seen that for a contract to start, there must be offer. An offeror must have to make an offer to the offeree. And an offeree must have to accept it. It is not enough that you want this same thing that this offeror wants. And so when the offeror has made the offer, you have now accepted it inside your own mind. No, you must have to communicate your acceptance to the offeror, whether by words or by conduct. So we've seen all that. But there is something very, very important. One of the elements of contract that must be there for this contract to be binding. Remember in our first lecture, we talked about why are contracts binding? And we looked at it and said, if contracts are not binding, then our economic life, our commercial life will be chaotic. Our commercial life will be riddled with anarchy. It will be anarchical. Because it will not be survival of the fittest. If you tell me to deliver something to you and you pay me, and there is no law binding me to deliver that thing to you, and contracts are not binding, and I am stronger than you, you cannot come and do anything because it's now a rule of might and not right. So if you talk anyhow, I will beat you because I'm stronger than you. So it will not be survival of the fittest. But thank God that contracts are binding. So we're not looking at this thing, consideration. And I'm saying all this to say that it is not enough that you made an offer. It is not enough that you accepted. Now you have accepted. At that point of acceptance, it is not yet binding unless consideration is furnished. The first lecture we had, I was talking about consideration being furnished when we looked at unilateral and bilateral contract. And I said that unilateral contract, the kind of consideration that is being furnished in unilateral contract is what? You forgot it. Executed consideration. While in bilateral contracts, the kind of consideration uh, uh, furnished there is what? You also forgot it. Executory consideration. Now, if you have not watched my first ever law of contract video where I did introduction to law of contract, this is the right time to stop. Go back, watch that one, watch the second one, offer, acceptance, before you come here. Because we are building this thing on top of each other. You cannot understand what I'm trying to say here if you do not understand offer, acceptance. Likewise, you will not understand when we go deeper if you don't understand this one. So contracts are binding because of the presence of this thing, consideration. And we must have to explain what consideration is so that you will know as a lawyer in equity or as a law student, so that you will know when a scenario is being painted, whether in your exams, whether live scenarios, if that scenario that is being painted, that maybe if it's a contract scenario, whether it is binding. And the only time you should know that a contract is binding on the other person is that this other person that is saying that the contract, I want to go to court, has furnished consideration. That is why there is a popular saying in law of contract that consideration must move from the promisee. The consideration must move from the promisee, which means if the promisor makes a promise to the promisee must have to contribute something that is of value in the eye of the law in order to make that promise binding on the promisor. I don't know if you understand what I'm saying. The promisor have made a promise. Remember, we define offer as a promise, an undertaking or anything made by a party with the intention that it will be legally binding on him once it's accepted by the other party. Now, if this thing is made, this promise is made, this promisor now has made this promise. Nothing is binding him. I will buy for you a aeroplane. Nothing will bind me to buy the aeroplane for you. Unless you, on your own part, you furnish a consideration, you do something of value in the eye of the law that will now bind me to buy the aeroplane for you. As I say, consideration moves from the promisee. The person the promise is being made to. That is why if you go in your family law, is it family law or something, where they will say that you see this action for um, um, breach of promise to marry. And they usually say that the only time you would have the local standing to sue somebody that have promised to marry you is when you have contributed immensely, whether expressly or impliedly, you have contributed immensely to the promise that he has made or she has made, because not only he that will make promise. Let me not just put it. Let me not just have this gender particularity. So, if you have not contributed anything in the event of the promise that the person has made to you that he will marry you, you cannot bring any action, because one of the elements you must prove is the things that you have committed, the things because of he has promised to marry you, you have done this, you have done that, you have bought your wedding gown, you have so that is where you can now sue and claim for damages. But apart from that, you don't have any local standing. So mere promise to marry is not just going to be actionable if you have not. That likewise it is in a contract. If you have not done anything valuable in the eye of the law, you cannot be talking about contract. You cannot be saying that you are entitled to it. The only person that has the powers or the local standing to go to court, the only person that has the right to enforce a contract is the person that has furnished consideration. Now, I will give you an example of consideration. Consideration, for example, you go to the market to buy something. If you receive the goods from the person, that person has furnished consideration to you. Yeah? You paying the person, that you have paid, you have furnished consideration. That is why that atom or that element of reciprocity in contract is coming into play here. Remember the notion of quid pro quo we talked about. You see, you cannot understand this thing if you have not watched the previous videos. Quid pro quo, this for that. I do this for you, you do this for me. Everybody is happy. But if you do this for me, and I don't do what I am supposed to do for you, you will be you will not like it. You will feel cheated. So you cannot bring an action. For example, I go to buy that same thing that I went to buy, and the person has given me the thing that I said I want to buy, and I refuse to give money. What do you think would happen? The person that have delivered that thing to you will ask for money. If you do not pay the person the money, the person will now sue to enforce the contract. Why is the person having that authority or that right to sue? It's because the person has furnished her own or his own part of the contract. And that means the person has furnished consideration. Now, it is now you that has not reciprocated that consideration that he has furnished. So I don't know if you have understood what consideration is. What moves from me to you, what moves from you to me, and it must be valuable in the eye of the law. Valuable. It must be something of value in the eye of the law. Now, what is consideration? Now, I said all these things to explain what consideration is, but let us go into our outline. We will look at what is consideration. We'll look at absence of consideration, the consequences, and the forms. Which means, when you talk about consideration, if there is no consideration, what are the consequences of absence of consideration? And what form does it take? So it is important we look at these forms so that we will know in our exams when they will paint a picture that is mirroring these forms. You will now know that the lecturer is trying to catch us here. There's no consideration here. You write there's no consideration. You understand? So let us start. What is consideration? In the case of Courier and Misa, this is a very a very great locus classicus when we discuss the definition of consideration. In Kuria and Misa, the judge, Lush J, defined consideration as consisting of RIPB. So in order for you to remember it, rights, interest, profits, and benefits. RIPB. So rest in peace, B. Consists of rights, interest, benefits, rights, interest, profits, and benefits accruing to one party. Or some FDLR, yeah? Forbearance, detriment, loss, and responsibility accruing from another party. So, if you want to remember the definition of consideration as Lush J in Kuria and Misa put it, you say consideration consists of RIPB, right, interest, benefits. No, RIPB, right, interest, profits, and benefits accruing to one party, or forbearance, detriment, loss, responsibility accruing from another party. So RIPB, FDLR. So sorry, when I was in school, this is how I usually used to remember things. We call them mnemonics. So we wouldn't really be it won't skip our memory when we are in exam hall and when we need it the most. So that is it. When you say rights, benefits, interest, profits accruing to one party, it means that when you want to talk about consideration, it should be valuable in the sense that the other person that you're furnishing consideration for must benefit in some way, must have some kind of interest in some way. He must have accrued to that person some kind of benefit, some kind of rights. For example, when we talk about rights, accruing, I want to buy this land. Something of benefit or something of interest is that you give me the land. That is consideration on your own part. You have forfeited your interest in that land, and I have come into this thing because you have furnished consideration. Now, on my own part, I'm supposed to give valuable, that is money, to you, which on your own part is beneficial to you. You understand? Then it says, or forbearance, detriment, loss accruing from the other party. So, if you are furnishing consideration, it's not enough that the other person has gotten benefit. It should also be that something of virtue is leaving you, something of value is leaving you. That is when the court will now say, okay, you have furnished consideration. Because if I bring out 275 million to buy 2 plots of land in a very developed area, the 75 million naira is leaving me. It's like a loss to me. But in return, I'm getting benefits. I'm getting some kind of right, some kind of interest. So that is why consideration must be quid pro quo. That is the reciprocity we were talking about in the other video. So if there is no consideration, imagine loss has gone out of you, virtue, value has gone out of you, and the other person has refused to furnish consideration. The law of contract now gives you the right to sue, because now you are suffering injury because you have lost, but you did not benefit. So contract, it should be, do me, I do you. Man no go vex. But if you do me and I don't do you, you go vex. Okay. So that is consideration. That is, we've just been talking about what consideration is. We have just been describing consideration so that we understand it. So that when we enter into the types of consideration, when we enter into some kinds of categories of consideration, we will not have problems understanding them. So we have absence of consideration. When there is absence of consideration, what happens? Even as I have been explaining what consideration is, I think I've talked about it. Absence of consideration gives the other person the powers to enforce. That is, if consideration has come from one person. However, if there is absence of consideration at all, there is no consideration at all in the whole contract, it means that the contract is not binding. It means that nobody can come and enforce the contract. So when we're talking about absence of consideration, we're saying this contract lacks consideration and as such cannot be binding. So for you to see a scenario, they will paint a very beautiful scenario and say, advise the parties on the bindingness of this contract. You have to first look for whether or not a consideration has been furnished. Because if you look at the consideration side and you now say, okay, there is no consideration here, you can now authoritatively say that the contract cannot be binding. Are you with me? So, what are these forms? Because your exams might come in these forms for you to show if this contract is binding. They will remove the consideration somehow, painting a scenario, and then now say advice on the bindingness of the contract. And when you look at it and it takes some of these forms that I'm going to talk about, you now say, okay, there is no consideration in this contract. So number one form is gratuitous promise. Now remember that when we were doing formal and simple contracts, we said something that formal contracts are contracts under seal. These are deeds under seal. And so the only time that you would not be expected to furnish consideration is when your contract is under seal. Formal contract. Categories of contracts in the first contract law of contract video we did, introduction to law of contract. Now, other forms of contract or other categories of contract are now known as simple contracts. Because formal, under deed, simple, any other, and for simple contracts to be binding, there must be consideration. So you can, if you want to give somebody a gift of land, you can prepare a deed of gift, and that gift, it will not be binding on you to give that person that gift if you prepare a deed of gift. But if you just gratuitously say, see, I will give you a gift of land, and you, on your own part, did not really do anything of value. You just stayed, they promised me a gift of land. And maybe very soon that other person says, no, I'm not giving you again. You cannot sue. Because you are the promisee. The promisor promised you gift of land. You are the promisee. You did not do anything in the eye of the law to make the promisor binding on his promise. So you're not entitled to it. But if that promisor had executed a deed of gift in your name, then it is binding on him. So we are not talking about formal and simple contract. We are talking about simple contract because, of course, apart from that contract under seal, gratuitous promises must have consideration. So if there is no consideration in a gratuitous promise, I like you, I will give you 50,000 for your upkeep. That is gratuitous promise. And mind you, it is very important to note this. Love and affection is not consideration. So you cannot say, my father told me that he would buy me this. He will buy me a car after I'm done with my secondary school. And your father did not buy the car, and you come to court. And the court is telling you that you don't have consideration. You cannot argue that because the love and the love and the affection you have showed your father, even that time he was sick, you are the one that was cleaning him up, you are doing this, you are doing that, he was bedridden, blah blah blah, before he now got himself. So that is enough consideration. That is not consideration anything. Consideration must be of value in the eye of the law. It must consist of RIPB, yeah? Rights, interest, profits, benefits accruing to a party, and forbearance, detriment, loss, responsibility accruing from the other party. It must be something valuable in the eye of the law. When we mean valuable, the court must look at it and say, okay, this thing is of value. Love and affection is not monetarily, cannot be monetarily evaluated. There is no particular, when we now talk about adequacy and sufficiency of consideration, how do you now measure love and affection? So it is not easy, it cannot come under consideration. So gratuitous promise is a form of absence of consideration. Now, non-performance by plaintiff. Plaintiff is, of course, the person that sues. So if a promise is made and my own consideration to that promise is dependent on your action. For example, if you say there is a contract between us that says deliver me 15 trips of sand and I'll pay you 50,000. Now, in the contract, you said I will pay you a part payment of 10,000 for you to deliver the 15 trips of sand. If I do not pay you that part payment of 15,000, you cannot bring the strip of sand. So if I have not paid you that 10,000 part payment that was in the contract that I will pay you, I cannot bring an action that you have not furnished consideration. Because probably you were the one that made the promise. Please, I will bring 15 trips of sand. Yeah. But in order for me to for that trip of sand, for you to be binding on you, I have to pay you 50,000. But of course, I'll first pay you 15,000, or sorry, 10,000, and it was signed and sealed. No, no, not sealed actually, because when you see, you don't really need consideration. So now I'm not waiting for you to bring the what do you call it, the trip of sand. Of course, I've made a promise. For that strip of sand to be activated, to be brought, I must have to activate it by paying a part payment of 10,000. And if I have not made a part payment of 10,000, I cannot sue you for not bringing the trips of sand, even though we have exchanged promises. Of course, when we get to executory consideration, we'll see that executory consideration is exchange of promises, undertaking. I will do this, just like guarantee. Yeah. If this person does not repay the loan, I will repay the loan. We now sign exchange of promises. So, if I have not done my own part of the bargain, yeah, I cannot sue. In fact, this is even talking about the whole notion of consideration. This non-performance by plaintiff. You must have to perform your own part before you can sue. Before you have the local stand, before you have the right to sue, you must perform your own. So that is it. Consideration is furnished by a third party. Now, there's something we call privity of contract, privity or privity. I don't know how. I don't know. This my board is. I don't know whether you can see what I'm writing. Privity of contract. Privity of contract entails that it is only people that are in the contract, parties to a contract, can enforce that contract. When we get there, we probably would get there. We'll explain it more. So, when consideration is furnished by a third party, which means a party that is not in that arrangement, I enter into a consideration, a contract with you, and another party is furnishing that consideration. It means that that party that furnished that consideration will be the one to sue. Even if I'm to sue, I am not suing you in my name. I will have to sue in representative capacity of that party. So, if we enter into a contract and if consideration is furnished by another party, there is absence of consideration between the two of you. And privity of contract entails that it is that person that will have to sue you for the consideration he has furnished. So that is it. Claim in excess of benefits provided for in agreement. So we have entered into a contract. We have furnished consideration. We have furnished consideration. I will pay you 50,000 for you to bring 15 trips of sand. You have brought the 15 trips of sand. As you are coming, and I say, I've paid you for I've paid you for the 15 trips of sand. So when you come, you now drop it. And that sand was to be used to fill up a particular place that flood has been, disturbing, or muddy waters. So when you come, as you are coming, you will now call me and tell me, okay, that you will help me and disperse the sand when you come. So no problem. When you now come, even though that you dispersing the sand is not part of the agreement, it is an excess of benefits. So I must have to furnish consideration for that additional benefit you want to come and do. I don't know if you understand what I'm saying. You are bringing trip of sand for me. That is what I paid for. I did not pay you for labor to come and use it to disperse because flood is disturbing me. I needed that trip of sand in order to fill up some places. So, and we were talking about it, I called you and I told you that this is the reason I wanted this sharp sand for. I said that if you come, you will do it. So I cannot sue you if you now come and say, "Ah, I'm not doing it again," and you now go. Because the consideration I furnished did not also cover you dispersing the sand or working with the sand. So for that promise of saying that, okay, I will disperse the sand, I am expected to furnish another consideration in order to make it binding on you when you to so that when you come, it is binding on you to disperse the sand and do the work that is supposed to be done. So that is it. So if there is no consideration in excess of benefits, then there is absence of consideration and it is not binding. Of course, the consequences is that it is not binding on the promisor. So when we come next and we look at executed and executory consideration, when we will now go into it, we look at executed, we look at the fact that executed consideration is when a promise is made in return for an action. And when we look at executory consideration, we will now see that it's when promises are exchanged. You undertake to do this, I undertake to do this, and we sign and we go our way. We also look at past consideration. What is past consideration? So I'm telling you what we will look at so that you go and read it up. So that when I start discussing it, it will flow. This is Prof TV. Please do well to like and subscribe. Thank you very much for watching.